Orientalism is definitionally the state oppression by categorizing.
Henry, you're not listening to the arguments in the AC.
Okay, then explain to me what they are.
All right,
so they seem to be the same thing based on what the language is.
No, right?
Okay.
Like, if you look at the society evidence, it's telling you it's not only policy, but discourse that affect this. You look at the Falguni analysis, Falguni tells you 1, 2, and 3. Falguni tells you specifically that the state uses laws to categorize and extend rights to one segment of the population.
So what sort of discourse?
You want me to answer your question, but then you cut me off and I'm not even finished giving you the other implications.
Okay, sure. The first implication is about discourse. The second one is about the categorization of people. Am I getting that right?
There's still 2 more.
Okay, then let's go through those.
All right. So then the third implication is how the state uses the law and uses specific gestures such as claims of justice or morality or to be liberal as a facade to deny these rights to extend them to other populations. The fourth justification coming out of the case is that the state uses physical characteristics as additional justifications to designate a group as a threat. And then they create some justification for that to continue to perpetuate
these 4 are all standard justifications, right?
They not only you're talking about the arguments I just explained.
The 4 you just explained justify your standard of minimizing Orientalism. Is that right?
That is the explanation of what minimizing Orientalism is. But the question you asked me also referred to the value originally. I was explaining to you what categorization is. You need to understand what Bodine is talking about when she talks about how the state uses the violence of law as the root for that categorization.
All right. Then thanks for explaining it.
Cool.
Then, so, how does the AC solve for these harms, for Orientalism or the categorization that you're talking about?
Okay. Well, we can go through the 7 different ways the AC solves. All right. We can go through those now. Sorry, prep?
Yeah. Before we start, can I get the stuff that you read?
Yeah, I was putting it down for you. I just didn't want you to get the first paper because it was blank.
All right. Thanks. And then
these numbers at the bottom.
You also took off the laptop, right?
Yeah, for Reddit.
All right. If I get that, that'd be great too.
All right. Writing starts at the 3rd point, and then you scroll down.
Where at?
3rd Reddit. And there's more. There's analysis under Reddit. All right. You want to start right now?
Yeah, that'd be fine. All right, another question. What does the affirmative advocacy look like? Do you automatically transfer all violent juveniles to the adult court, or is it something different?
That's what I just showed you on the computer with the Redding analysis. Redding shows you that we use, I'm enacting it in proposing that we use certification hearings, universally. And we give juveniles due process rights with those certification hearings. Redding evidence explains that.
Okay. What is a certification hearing?
A certification hearing determines if they will be treated as adult, but we can give individuals rights within certification hearings. Like we can give them the right to an attorney, we can give them the right to appeal, we can give them the right to move freedom of movement. We give them that.
Is that the only thing you defend? Only part of the advocacy?
No, right?
Okay.
Like if you're running arguments that say the adult criminal justice system is bad, right? Or if you can make arguments that talk about why I am Orientalist, I will defend and engage those disadvantages. I'm not parametricizing to that one part.
Who enacts the laws that allow these certification hearings to take place?
The certification hearing,
The government, right.
the state
The state.
enacts these certification hearing laws. They're already enacted in 20 and 45 states.
All right. Awesome. After the certification hearings, juveniles go to the adult court, right?
Now, after the certification hearing, if it's ruled that a juvenile.
All right, assuming that they should be transferred per the certification here, they go to adult court.
Yeah.
Okay.
If the certification has rules that they need to be sent to the adult court, they go. The certification here could rule likewise and say, we don't think this should be transferred.
Do you defend the possibility of juveniles getting a certain punishment, or is that entirely out of the question?
The argument, I answered that argument in the top of the AC.
All right, if you could explain to me again.
The resolution is like, when you say possibility, you're referring to the trial process, right?
No.
Yeah.
Some juveniles will be punished, right?
That's based on what happens in the second phase of the criminal justice system, which is the trial process. So I will defend the legitimacy of the trial process, because that determines the possibility or not.
Okay, but you will defend the possibility that a juvenile could get a certain type of conviction.
Possibility is based on the trial, right? Now, if you're asking me if I defend like the impacts of what happens after the trial, i.e. like jail, the textuality arguments address that. Resolution is only referring to pre-trial and adjudication services, second, third.
All right, 25 seconds left.
I see the last out that too.
Sorry, what?
Laptop.
Oh, yeah.
You still need the AC?
Yeah, probably. But, right, sorry.
You do need the AC, right?
Yeah.
All right, cool.
All right, so the order is 2 off AC.
Just take like a second pause between those two. So
Okay.
what should I label the second one? The first one.
NCCP.
Two
2 off.
two off AC.
Yep.
Yeah.
The state is draft the resolution because only it have the power to charge juveniles either adult or criminal justice system. This is something that he concedes to cross-examination. The valid word of the resolution is oddly linguistic, which is the word "oh." Therefore, the standard must be consistency with international obligations. First, standard establishing international law generate obligations. The Washington Quarterly explains. International laws were created through the consent of states behind the understanding the assumption that states are sovereign, willing to be bound by no high law, that the consent is the consequence of lawfully do as they please, unless they consent to specific rule that restricts the payment of the rules of law behind upon states. Therefore, any from the own free wills expressed in the convention or usually just generally accepted as expressing principles of law and established in order to regulate relations and coexisting independent communities or with the view of achievement of common aims. The act of making promises thus generates an obligation, and then unilaterally nullifying a contract is unacceptable. Second, international law generates legal obligations from treaties, customary uses established by Supreme Court precedent. The Supreme Court explains. International law as part of our law must be asserted and administered by the courts of justice. Off questions right to depend on what duly presented, but there's no treaty of executive legislative act, judicial decision. Resort must be had custom civilized nation of the war of jurisdiction, accommodates trust with the evidence of the law really is. This indicates the legal obligation drive customary standards established through international law to monitor from domestic international spheres. Third, even constitutional laws can say by international agreements because of the supremacy clause of the Constitution delegated latent right. International laws expressed in treaties and agreements of the Supreme Court of the land, U.S. should be applied in the context of juvenile sentence supremacy clause, Article 6, Clause 2 of the Constitution states, this Constitution laws U.S. shall be evaded pursuant thereof, and all treaties made under the authority of the issue shall be the Supreme Law of the land, judged in every state should be bound by it. Finally, unlike individual which are moral, legal entities, states do not exist as in the law, and that they only act in accordance with codified law, not based on some other ephemeral contracts, such as only mentioned by